In July 2025, Priya Sharma, a 32-year-old Tempe nurse living in a gated Chandler HOA community, was attacked by her neighbor's Rottweiler, suffering deep lacerations that required 40 stitches, tendon repair surgery in her right hand, and psychological trauma that threatened the very career she had spent years building. Because, as a nurse, her livelihood depended entirely on the fine motor control, drawing blood, placing IVs, administering medications, that the hand surgeon now told her she might never fully regain. The dog owner's immediate response was to apologize and then say he couldn't be held responsible because the dog had never bitten anyone before. The HOA's property manager sent a letter 2 days later denying any liability. And Priya, in pain, frightened, and facing the possible end of her nursing career, had no idea that both of those defenses were legally meaningless in the state of Arizona. Arizona Revised Statutes, Section 11-1025, is one of the strictest dog bite statutes in the entire country. It imposes strict liability on dog owners for bites that happen in public places or when the victim is lawfully on private property, and there is absolutely no first bite rule in Arizona, meaning the owner is fully liable even if the dog has never shown any aggression before and the owner had zero reason to believe it was dangerous. Priya's attorney filed against the dog owner directly under Section 11-1025 and separately against the HOA for failing to enforce its own CC and R regulations. Because the community's rules explicitly prohibited dogs over 40 pounds without a registered permit, and the Rottweiler had none. A hand reconstruction specialist testified to a 35% permanent loss of fine motor function. The HOA settled for $45,000 for negligent enforcement, and the dog owner's homeowner's insurance paid $285,000, covering surgery, 2 years of reduced nursing income, future occupational therapy, and emotional distress. The first bite defense never applied, not for one single second.